Tonight, the hot debate over North Carolina's voting districts is back, with the argument over whether voters can ever be promised a fair election. Lawyers for state legislative leaders were back in front of judges today, arguing to dismiss one of the suits against the maps, which were created in October. Here's Laura Leslie.
North Carolina's state constitution says you have the right to free and frequent elections, but it doesn't specifically say they have to be fair. Former Republican Supreme Court Justice Bob Orr is representing plaintiffs who say that right is so fundamental it's implied.
A fair election is the very floor to our democracy. If you don't have fair elections, you don't have a democracy.
Orr says when lawmakers draw voting districts so they're more likely to elect one party than the other, it amounts to the government violating that fundamental right.
We just want the election to be fair. And the only way it can be fair is if you haven't stacked the deck on who gets to vote for that particular office.
Attorney Phil Strack represents state lawmakers in the case. He says there's no legal definition of fair that lawmakers could follow.
But if the court says, well, these districts aren't fair, what in the world are they supposed to do about that?
Strack urged the court not to add a new right to fair elections to the state constitution. He predicted it would result in an avalanche of lawsuits by anyone who loses an election or doesn't like the outcome.
An unintended consequence, perhaps, of very bad law based on just making stuff up.
Last year, the state Supreme Court ruled that partisan gerrymandering is allowed and that the courts don't have the authority to stop it. That's why state lawmakers are asking the court to throw the case out.
Now, Orr says this case is different than the one the court ruled on last year. We should know a decision in a couple weeks.